May I please? Worship, case is registered under section 21B.
Okay. NDPS?
NDPS, CD.
CD code. When was he arrested?
6/9, my lord. So it's 28 days.
Call for the case.
32 days.
Call for the
This
case
is
diary of
32
Borlumuk PS case. I think come. Borlumuk PS case number 132 of 25 under sample. The accused is in custody since 6/9/2025. Fix list on next week. Next next week. List on next week.
23rd, my lord.
You want it on 23rd? You want it on 23rd? No, I can fix it next week also. You want it next week or 23rd?
18 possible.
You want 18? 18.
18
Oh,
Saturday.
sorry,
my lord.
sorry. It is
Maybe 23rd. my lord.
23rd. 23:10.
Wait, please, Your Lordship. For 83 main application, the FIR is page 12.
Ilasi Para. Cattle preservation.
53 days.
When was he arrested?
Arrested on 6th of August.
6th of August.
Today is 63 days, Lordship.
My lord,
The
then
mandatory is 60 days, Lordship.
I have to take instruction whether a charge sheet file or not. I'll take telephonic instruction, my lord. Maybe charge sheet file in the meantime, my lord. Otherwise, they will get deferred bail.
Lordship, as per my instruction, Lordship, the
Charge sheet has not been filed.
not filed, Lordship.
When can you take the instruction?
My lord, today itself, I'll
Oh.
take telephonic instruction. my lord.
Okay. He'll take telephonic instruction.
Obliged.
To something.
May I please, Your Lordship, my lord? He is arrested on 6/9, my lord, 33 days behind the bar, my lord. Is there may be required, my lord?
Is there? District? Is both, yes. Third and Mahajan, Learned Council. Call for the case diary of Dispur PS case number
Yes.
748 of 25. Section accused was in custody since 6/9/25. When do you want it?
Next week, my lord, so if
This is under
theft and
My lord.
extortion, my lord, power of.
suggested it.
16, my lord.
60?
16.
1610.
Well, Lordship, may kindly observe that our primary prayer for bail is on the non-compliance 35(3), my lord. We've annexed several orders, my Lordship, kindly observe that.
Learned Council submits that the primary contention for seeking bail is non-compliance with the provisions of section 35 subclause 3 of BNSS 2023.
That will be
List on 16/10/2023.
Well-
It'll be good. I'll remember all, whoever takes it, I'll remember.
obliged, thank you.
$19,900. They're arrested on 19. Forgery kind of. Should we call for the case diary?
Yes, it's very much. Well,
Call for the case diary of Dispur PS case number 108 of 25. Accused was arrested on 19/9/25. List on, next on
23rd.
23rd. 23:10. Now, since their counsel is not
My
there,
lord.
so
Oh, my lord, list.
we can little earlier, maybe.
My lord, that can
Little
also be done, my lord.
Huh?
CD may be called for or otherwise.
CD
my-
is called for, right?
Yes.
23rd or it will be little earlier? Your date, you see the date, because
My lord, 17.
17,
17.
17:10. 17:10.
Yeah, legal bill application, Lordship. He was arrested on 25/9/25. A case of 64 BNS, Lordship. CD may be called for. 14 days behind the bar as on today, Lordship.
Yo, Mr.
SK Chetri.
SK said, learned counsel. Call for the case diary of Silchar, is case number 951 of 20. He was in custody since 25/9. List on
My lord, it's from Silsor, my lord, 23rd, my lord.
2310, oblige. Six is.
My lord, he has been arrested on 6th of August and equal to case time.
Okay. It is 22C. Call for the case diary, this case. You are Mr. Sharma?
U Prasad,
You, Prasad.
Umesh Prasad.
Mr. Umesh Prasad, learned counsel. Call for the case diary of Gorsuk PS case number
Gorsuk, my lord.
235 or 25 under section 22C NDPS Act. The accused petitioner is in custody since 6/8/2025. List on. This will require a proper
From
hearing.
Gorsuk, my lord, 1710.
No, a little bit, because it's commercial quantity.
Yes, my lord, commercial.
Time of issue.
Yes,
Will
yes.
require a proper hearing under
Yes, yes. my lord.
37 in any case. So,
Yes,
it can be
Then my
immediately
lord,
after
on-
that.
then my lord on 23rd or 24th.
23rd.
23rd, my
Is
lord.
it okay?
Yes, ma'am, because commercial quantity.
Transfer for the time being, Lordship. Mr. Arali, report number 13, Lordship.
So good. 70 के time में लगा, 8
May Lordship. Lordship for 82 application Lordship, FAR page 9, vernacular page 13 Lordship. Offense not committed Lordship, just try Lordship, all section are available section Lordship.
All bad.
Vernacular FAR page 13 Lordship, 13.
Go ahead. Should we read it?
Yes Lordship. হনমারব্রক বিনোদন নিবেদন এই যে আজি ইংরেজি 15 আগস্ট 2025 তারিখে দিনের প্রায় 11:30 বজাত উপরোক্ত পদকীয় জনে বরমপুত্র বেলিভ একাডেমিত স্বাধীনতা
day and night. Since the commencement of the work, certain miscreants of the public have been creating nuisance, instigating others and attempting to hamper the ongoing work. Therefore, the police personnel have been deployed around the clock at the site to maintain law and order. On 28/2025, so-and-so was on duty at Erosion Bund from 8 AM to 3 PM. At about 11 AM, he informed the IC of so-and-so outpost regarding the tension situation in the site and requested additional force to control the law and order. Accordingly, IC made an GDNT number so-and-so, dated so-and-so, and deputed me along with so-and-so. Subsequently, at about 11:45 AM, while on duty at so-and-so Erosion Bund, along with the SI so-and-so, the police party was performing lawful duty and trying to disperse the public gathering crowded. At that moment, a group of persons led by 3-4 persons, so-called local leaders, criminally attacked me, shouted anti-police remarks, wrongfully obstructed the police party and assaulted me with intention to cause grievous hurt and even to murder. By doing so, they deterred the police party from discharging our government duty as police personnel. My lord, the petitioner, my lord, he is a resident of that my lord area, my lord. And the alleged incident, my lord, took place near his house. He was not present in the house. Even, my lord, his name has been implicated in the FIR. And the main person, my lord, who are involved, my lord, they were arrested. I have annexed their forwarding report, my lord.
Your instruction is that he is not.
No. Because the incident took place near my house. So, my lord, they suspect that I'm also there, my lord. Actually, he was not present in their occurrence also.
Like section 109 of BNSS is there, मतलब, it's up to life. So, मतलब, his
Attempt to.
attempt, his, मतलब,
From the FIR ingredients is absolutely missing.
his role has to be verified, मतलब, from the case.
I'll cooperate with the investigation, my lord. I'll,
Let, short that.
lordship may call for a case diary and in the meantime, my lord, I may protect it. I will cooperate.
R. Ali, learned counsel. A good name, please, sir.
KK Parasar.
The KK for learned additional PP. State, The petitioner is seeking anticipatory bail in connection with South Salmara PS case 103 of 25 under section 12. And councillor, the case arose out of FIR dated, what is the date of the FIR? 25 bis pass, 25 lost by a police official with the allegation. No, sorry, bis pass. Sorry, no, bis act. Bis pass are all executed. This is some. Allegation. The gist of the allegations in the FIR is that in connection with some activities of district administration to control erosion by the riverside in that area. On the day of the incident, the informant, some police officials were on duty and whereupon a group of persons criminally attacked them and obstructed the police duty. Full stop. It is also alleged that the miscreants assaulted the police with the intention to cause grievous hurt and even murder. 9 persons have been named in FIR and 20 unnamed others. Mr. Ali Learned Counsel submits that the house of the present petitioner is located near the place of incident. And though he is not yet at all connected, but he has been falsely implicated and also named in the FIR. The learned prosecution opposes the bail petition. Call for the case diary from the concerned police station. However, in the context of the aforesaid contentions, perhaps the petitioner can be given an opportunity to record his statement first. Accordingly, 20,102 appear before the IO and record his statement.
Definitely.
30th of October.
3010. No, 30 is, I can just check whether it's a. 3010.
May I please, Lordship? The anticipatory bail application, Lordship, FIR page 13, Lordship. Yes, sir.
Page 13.
Page 13 is the FIR, Lordship. Basically, Lordship, against 2 person FIR was lost. One is Sujit Dutta, another is Aditya Sagar Panifugan. The petitioner is Aditya Sagar Panifugan, Lordship. And Sujit Dutta already approached before the Honorable High Court, Lordship. He was approached before the Honorable High Court and granted interim order. I have annexed the copy of the order, Lordship.
What happened? What is the allegation?
Allegation is that what
Yes,
happened,
okay.
Lordship, there is a shopping mall in Jorhat, Lordship. Their manager involved in a molestation case of a working girl, Lordship. And that's why the victim girl, Lordship, come to,
Respect is there
Yes, fine.
in your favor, is that it was transferred from the original execution.
Yes, Palla. In 2015, that case
That aspect is there,
That-
otherwise.
that execution case filed on 2015.
As we
after
know,
2 years.
yeah.
And
As
one
we-
judgment of the apex court. When notice has been given, you have to give all the copy if the asking. Without going to it, the petitioner will be prejudiced.
Anyway, because the judgment has attained finality,
Yes,
you
Palla.
know, after 2000, after a second appeal.
Yes, Palla.
So at this stage,
Yes,
we'll admit it until the returnable date, okay,
Yes, ma'am.
let it be unstay, but you take the steps quickly.
Yes, Palla. I have filed a miscase. IS appeal T274. Next.
The Justice, Honorable Justice Pardiwala has been, you know, he has
Yes.
passed
Yes, Palla.
very strong orders on execution. Because,
Yes, Palla.
see, the suit is of 2012, just imagine.
Yes, Palla.
So anyway, but you have a grievance
Yes, Palla.
that you could not file an objection, that will be
Yes,
looked into surely. Interim he could go, I.
Actually, look at this.
This main case has to be admitted.
Yes, Palla.
It has to be, issue notice at this stage.
Yes,
It has
Palla.
come up for motion.
Yes, Palla.
Let it come up for admission. It may be
Okay.
possible to dispose of admission also. Heard NNB Chaudhary Learned Counsel assisted by kindly PK
PK Bas.
Bas, councils, full stop. The full stop. The petitioner was invoked the provisions of Article 227 of the Constitution of India, read with Section 151 of the CPC 1908, is agreed by order dated this now 29/2025. This now passed by the learned Civil Judge Senior Division, Baksa. Baksa or Nalbari?
Baksa, my lord.
Baksa.
Now Baksa, my lord.
In title execution case number 1 of 2025. Full stop. The original trial court judgment was passed by learned Civil Judge Senior Division, Nalbari on 14/8/2013, which was affirmed by the learned District Judge, Nalbari on 22/1/2015, and finally affirmed by this court on 15/7/2025 in RSA 99 of 2025. Subsequently, the execution case was initiated, and though it was filed in Nalbari, but later it was transferred to the learned court at Baksa due to the location of the suit property. Full stop. The grievance of the petitioner is that though on the said date, that is 29/2025, this now, the petitioner entered appearance to learned counsel by filing wakalatnama and wanted to submit an objection, but the same was disallowed, thereby prejudicing him. Issue notice upon the two respondents. Steps may be taken expeditiously. Call for scan copy, will call.
Yes.
Call for scan copy of the TX. Title execution only will call for.
Yes, ma'am.
At least scan copy of the case record of TX, title execution case number. So and so it will follow from the Court of the Learned Civil Judge Senior Division, Baksa. Next date will be for admission.
Admission, my lord.
Or after list on so and so date in the admission column. We will fix a date or after, let's fix a date, that will be better for you also, it will be quick, that's okay. 1 month,
1 month, my lord, service is necessary.
little more than 1 month. So then, after this,
Now the High Court is also closed, my lord.
13/11.
Yes, ma'am.
Okay. 13/11. We will hear the IA properly after they appear, but till the returnable
Yes.
date, it will be still, no? So this will not be disposed of.
Yes, my lord.
That's what I'm trying to say.
Yes, ma'am.
IA 3274 of 2025. Yeah, same, NNB children. আগৰখিনি একেই হ'ব, মই মিলাই দিম এইখিনি। In this interlocutory application, filed under Order 41, Rule 5, CPC read with 151 CPC. The applicant petitioner is seeking stay of the impugned order dated this now 2025, passed by so and so. And Learned Civil Judge Senior, Baksa, title execution. Issue notice upon the two respondents. Steps may be taken expeditiously. Till the returnable date, till the next date of listing, further proceedings in TX shall remain stay. The needless to say that the respondents, upon their appearance, shall be at liberty to seek vacation, alteration, or modification of the aforesaid interim order, right? List on same date,
Same.
13/10.
May I please, your lordship?
Mhm.
My lord, I may be allowed to withdraw this petition, my lord.
Withdraw.
With liberty, with
As you
liberty.
wish, I just seen the cross case,
Yes,
they
my
have
lord.
filed.
And the state has not been made party, that's why. The state has not been made party.
It will be necessary, complaint case.
Yes, my lord.
That's a technical reason you want to
Yes.
read and file again.
Yes, my lord.
Learned counsel, your good name, please.
I Rafiq.
I, Rafiq. Learned counsel, assistant.
S. Chaudhary. S. Chaudhary.
And submits that he wishes to withdraw this petition with the liberty to file a fresh one as the state needs to be implemented as a party, which has not been done so. It is submitted that for this technical reason, the prayer may be allowed. Considered the matter, the instant criminal petition disposed of on withdrawal, semicolon, with a liberty to file a fresh one
Yes, oblige,
after impleading all the parties,
oblige.
necessary parties. Disposed of, disposed of.
This inspection, my lord, already charge sheet filed.
Charge sheet has been filed. Charge sheet was filed, any idea about the date? Because
Yes, my lord, CS number 258/25, dated 29/9/25.
29/9.
So prior to, my lord, 60 days.
That was the period behind the wall of this with the 63 days lordship. And during this, the puja vacation lordship, the police filed the charge sheet lordship.
He was arrested on 6/8, 6/9, 6/10. 29/9 it was. filed.
29/9.
As per my instruction lordship on 26 lordship September, my bail petition has been rejected with the trial court lordship.
Let him approach the trial.
That is one option. Would you like to approach the trial court? Would you like to approach the trial court? What is the say provision? Cattle preservation
Provision,
Cattle letter.
cattle preservation.
can be allowed also. It can be disposed of also, considering the nature of the matter. DA 2326, the learned, your good name, Mr. Shah,
MZ Shah.
MZ Shah, learned counsel. 483 bail application seeking regular bail for for accused Mithu Biswas, these two persons, in connection with Bilasi Para PS case number 226/25. 203/13 on cattle preservation. It is submitted that the accused persons are in custody since 6/8/2025. The Mr. Parasar, learned additional PP upon instruction submits that in the meantime, charge sheet has been submitted by CS number.
CS number, my lord, 258/2025,
258 of 2000, dated 29.
29/9/25.
29/9. Considering the nature of the alleged offences and comma semicolon, the length of pre-trial detention and the completion of investigation dash the I deem it fit to grant bail to the accused persons at this case. According 25,000 it once is it. Available for trial, not hamper or tamper with evidence. Available for trial, comma, if one commences. Not hamper or tamper. with evidence. Violation and standard. The bail petition stands disposed of.
Lordship. Oblige.
May I receive? The civil revision to 21, civil revision.
12, my lord,
Please, your lordship.
should be not received, my lord.
Lordship, regular bail application 58 days, lordship, intermediate quantity, lordship,
Just a minute.
intermediate quantity 58 days to the lordship.
Is-
FL,
His diary has been,
Not received, my lord. We have sent twice, my lord, signal on 29 and 15/9. But till today. my lord,
somehow it has
signal-
not come. No? Which Thana?
Is from Tezpur PS.
Tezpur Police Station.
Arrested on lordship 11/8 and forwarded on 12/8 lordship, today 58 days lordship. And quantity is lordship 63 gram lordship heroin without container lordship. With container it's a 250.
Well, that's true.
37 rigor.
Normal course, I would have liked to, because since we are in the midst of this, it is a vacation court. In normal course, I would have liked to fix it on the 61st day, and then on that day, you can take instruction. If it's not filed, you'll be entitled to bail. But today is 58 days. No?
Yes, lordship.
Wednesday, Thursday, no, we are on, tomorrow also no purpose will be served because
Yes.
61st day will be on Sunday, Saturday.
It's on Saturday lordship.
Saturday. No, we can't fix it on a holiday. If you can take an instruction just like that, then we can, otherwise. What do you suggest, Mr. Prosecutor?
Considering the lordship length of
true.
detention, lordship
Yes.
37 rigor will not come lordship since lordship intermediate one.
But
That
NDPS
is not
case,
come.
also, we should
NDPS,
see the case diary.
That is this, but FSL also required, but
Ideally,
in case of
see the case diary.
otherwise, FSL in within 60 days is very less case FSL has come. That is also
Calculation is correct, no? 11/8.
Yes,
Lordship, I
11/8.
always use a date calculator.
August is
Yeah.
20 days.
No,
and,
September 30
is
today 8.
now
Date
today.
calculator, so 11/8 to. Because that way, there's no chance of error. Today is 58 days.
Yes, yes.
The condition may be imposed.
483 bail application. Hanif Ali. In connection, Tezpur PS case number 559 of 2025 under section 2021B. The gist of the allegation is about seizure of intermediate quantity of suspected heroin
Yes, lordship.
from the accused person. He is stated to have been arrested on 11/8/2025 and has completed 58 days in pre-trial detention. Full stop. The applicable statutory period is 60 days. It is submitted by Mr. Parasar Lanet additional PP that case diary has not yet been received. Today being a vacation court, by the time the court reopens on a regular basis on 13th, the said statutory period would already be over. Full stop. In the given facts and circumstances, the accused is allowed to go on bail of 30,000. Once you written, number one. He shall not, he shall cooperate with remaining investigation. Number two, he shall not indulge in any activity of consuming or peddling narcotic drugs. He shall not hamper or tamper with evidence. Violation. Bail petition stands allowed in this post.
To the satisfaction of special judge Sunit.
Sunit, learned concern court, special judge Sunit.
In
Yeah.
this case, maybe take after some time, just I have to take instruction whether charge sheet file or not.
After something?
Lot.
Clear lordship. 483 application, arrested on 45 days in custody lordship. 7 years lordship, 60 days lordship. Arrested on 25, taken into custody, everything has been recovered lordship. And section 7 is bailable
Oil
lordship.
tanker, Narangi petrol.
Section 7 is bailable, essential commodity.
And the plan.
Otherwise, malat 45 days no doubt, malat, but he is a habitual offender in this kind, malat, and
Maybe Lordship.
malat,
Kindly see
the way he has malat stolen the malat diesel. In any case, any untoward incident may happen, malat.
Lordship could kindly say that no complaint from the vehicle owner or from any quarters, Lordship. In this context, and bail has
driver-
been granted, Lordship. In a similar case, Lordship, coordinate based on this honorable court has granted bail, Lordship, to similar situated persons, Lordship.
Diary has come.
Yes.
Malat, yes.
Diary has come.
45 days in custody.
What is the investigation?
Investigation that petrol has been seized, malat, 6 plastic drum along with the malat, around 300 liters of malat diesel and 39 empty drum. They were seized along with the vehicle also.
They were allegedly trying to take away in the vehicle.
Yes, yes.
And
Lordship,
there's some
Thing is
materials to indicate heavy.
It is malat, okay,
Yeah.
but it at any moment, any untoward incident may happen. It is diesel or petrol, malat.
Yes.
And the driver of that malat, oil tanker, they may be involved, they may involve, malat, otherwise, malat,
Nobody has been arrested till now.
no, malat.
Till now, nobody has a 45 days. Where is the question, Lordship? 45 days in custody, 60 days mandatory period, Lordship. Investigation is almost complete, Lordship. I'll face the trial on any terms and condition, Lordship.
There are materials to indicate his involvement in a
Malat,
habitual.
my accused statement, malat, his own statement, malat, I have flag mark.
Only his statement, Lordship.
Habitual.
Lordship is 45 days, learned his lesson, Lordship. Any strict conditions, Lordship. If future this bail may be cancelled, Lordship.
In the forwarding report itself, he is involved in earlier Nunmati PS case number 350/17.
That the note has been succeeded, Lordship.
That is also, sir.
I have been told that within 3 days he was released on bail, Lordship.
Oh, this is not admissible, but he has said several times he has stolen. Earlier also.
This is not admissible. Similar cases, Lordship, bail was granted, Lordship.
Same case.
Similar type of cases, Lordship. Same type of offense. Within 15 days,
He
Lordship.
stays on
The investigation is complete. Bail was granted, Lordship. That's section 7 bailable. Decision of the honorable court, all are given, Lordship. For carrying below 2,500 liters, it is bailable in.
Mr. Prosecutor, no, it's okay, granting you the bail, but thing is that he is rightly contented that this handling of these items.
Storing is
has
another
strict
thing.
SOP, how to handle, otherwise.
Storing is another thing, malat.
Can
In a
blast.
yes, in the process of malat, downloading this
It has
from the
strict
container, malat,
SOP, these things, handling, how to handle. We cannot just go and take out from tanker.
45 days in custody.
Anyway, I'm considering, that's another thing.
There.
Hope he does not repeat.
Yes, Lordship. I will,
You can only tell what.
yes, I can tell, Lordship.
If he does not listen. to
Yes,
you,
Lordship.
What can you do? What
That is another thing.
That's another thing.
Yes,
We are
Lordship.
not prejudging, I mean.
Yes, Lordship.
Alleged. Yes, factors.
Thank you.
Four 83, Nunmati PS 165. Nunmati PS 165, 2025, 305, within bracket C, PNS. Read with section 7 of the Essential Commodities Act. The allegation in the FIR dated 25/8 is that the accused person was caught stealing oil from a tanker, oil tanker near Narangi petrol pump. And upon being confronted and asked, he could not show proper papers. Learned counsel submits that, Mr. Pradhan submits that, AK, learned counsel submits that. AK Saitya submits that. He has already spent 45 days in custody, having been arrested on 25/8/2025. Case diary has been received to the learned additional PP, Mr. Parasar submits that the suspected stolen oil, etc., along with the equipments and one small vehicle have already been seized. I've seen the progress of investigation. Full stop. Though the same is not admissible in trial, but the accused in his statement has stated about being involved in other similar offences as well. Nevertheless, considering the progress of investigation and the length of detention, when so allowed to go on bail of 30,000 with one security with light amount to the satisfaction of the concerned learned court. CJM Kamrup Metro, subject to the conditions. He shall cooperate with remaining investigation.
That's right.
He shall not misuse his liberty to commit any offence or illegal activity.
Deeply obliged.
Return case diary, well, she stands disposed to.
May I please, Your Lordship? Lordship, 483 BNS's application, Your Lordship, 47 days behind the bar, Your Lordship, FIR is at page number 11, Your Lordship.
Lordship, the CD has not been received. In this case, the CD will be required, Lordship.
Here, Your Lordship, my whole bail application has been filed, Your Lordship, based on the lapses of the procedure, Your Lordship, not on the merit, Your Lordship. Because, Your Lordship, the investigation agency valid section 35 of the BNSS, Your Lordship, guidelines frame under Satyendra Kumar until Adish Kumar, and Article 20 of the Constitution, Your Lordship. How, Your Lordship?
What is just before going further?
Yes, Lordship. 11 is the FIR.
What is the allegation in it?
Yes, Your Lordship.
I'll just go through.
Lordship.
Come, please.
Lordship, may kindly peruse page 13.
Yes, sir. Page 13, I'm on 11th.
11.
Page 13 will, page 13 will be,
Forwarding.
yes, that will be very clear, Lordship.
Financial,
Yes.
Lord,
They absconded, Lordship, after
provided any
appropriating
profit,
amount in the excess of 20 crores,
fail to
Lordship.
return.
So, Lordship, even
20
though,
crores.
yes, Lordship. So that is why, Lordship, the CD will.
Of course, CD will be necessary in this case. Generally, it will be necessary.
Yes.
Okay, so what is this let me see this contention. 35(3) has not been complied.
Not be complied, Your
Where,
Lordship.
where exactly?
Here, Your Lordship.
Description of, where is the notice? 10. This is Caesar list. Oh, it is, have you annexed? No,
There is no notice, Your Lordship.
there's no notice.
No notice, Your Lordship,
There will
under
be-
section 41. There is no even mandatory provision, Your Lordship, the writing, there have to be a writing, Your Lordship. The why the arrest, Your Lordship? Because the Satyendra Kumar until case is very much relevant in this regard, Your Lordship.
The grounds of arrest has to be given.
No, it's
And,
not.
Grounds for.
I'm not on the ground of arrest, Your Lordship, with due respect, Your Lordship, because my case has been registered under section 316, 3184, Your Lordship. The maximum punishment, Your Lordship,
years.
is 7 years, Your
So
Lordship.
this checklist,
Checklist, Your Lordship.
41, earlier 41.
Yes,
41,
41
41A.
is there, Your Lordship. Now it was 35, subsection
35(3).
3, Your Lordship.
Yes.
That was not there. Even, Your Lordship, the mandatory provision that have to be writing, why arrest, Your Lordship? That is also not there. I can understand the economical offense comes under the serious offense, your lordship. That is true. But it doesn't mean, your lordship, that the procedural aspect
Compliance
will
must be-
violate your lordship.
It has
Will be violated, your lordship. Now, if your lordship kindly see,
You're right.
your lordship kindly see, earlier also, your lordship, here, my name is not there in the FIR. I am not a FIR, I'm accused, your lordship. There are 4 FIR name accused is there, your lordship. Anirban Deuri, Debashi Barua, Bugul Deuri, Moon Devi. The rest of the, except Anirban Deuri, the rest of the persons are outside, your lordship. Even the main accused, Debashi Barua, got bail from the Honorable Session Court of Nagaon, your lordship.
Kashyap
No,
Fukon.
yes.
He's Kashyap Fukon.
Yes, Kaishap Fukon, your lordship. Even, your lordship, in this case, your lordship, earlier one case has been registered against me, your lordship. I'm punishing that thing, your lordship.
With due respect, Lordship, even if there is some violation, Lordship, I'm not admitting, Lordship, but if there is some violation, Lordship will have to produce the case that if
That,
there is a violation.
no, that's why I was about to ask you that
Yes.
since Learned Council has said that there is no notice, and so from the annex documents, it's not clear. So you have to guide the prosecution.
Yes, Lordship, that is why.
You are for the informant,
Yes.
My lord, not for the informant, I am for one of the victim, my lord. Now, this is a big.
one of the
racket, my lord.
victims.
Yes, my lord. So, my lord, I am one of the victim, my lord. I have lots of documents regarding their transaction, my lord. Now, by creating a false company, my lord, in the name of Bullseye, they are, my lord, looting the public, my lord, in the tune of, my lord, 40 crores, not 20 crores, my lord.
One FIR is there, your lordship,
See the
against
documents, my lord, they are, even they are.
I'll come to
my lord,
you.
issuing
Don't-
fact certificates, my lord. And my lord, this informant, my lord, Kaishap Fukoi, my lord, this petitioner, he is the main, my lord, kingpin, my lord, of this whole crack.
Why I am submitting, your lordship, there is
No, no.
earlier FIR, your lordship, let me speak. There's earlier FIR, your lordship, against the petitioner, this petitioner, instant petitioner, your lordship.
Where he got bail.
He got bail, your lordship. Now, your lordship, for the same offense, type of offense, your lordship. How a subsequent offense can be prosecuted, your lordship? Article 22, lordship, of the Constitution has been violated, your lordship, because without following the procedure of Section 35, without following the provision of Anis Kumar, without following the guidelines framing Satyendra Kumar until, your lordship, I have been arrested, your lordship. Even, your lordship, the similar type of offense has already been registered against me. I am on bail. I have cooperated, your lordship. This is not me who absconded, who fled away to Delhi, your lordship. It is Anirban Deuri, your lordship, not me, your lordship. Even, your lordship, the Devashi Borwa got the bail, your lordship, the main accused, your lordship. Here. Reduction. It's illegal arrest, your lordship. And Satyendra Kumar until speaks, your lordship, immediate release, your lordship, in this type of cases, your lordship. So my submission is on that, your lordship.
That's okay, but
Lordship.
this one thing, before going further, of course, case diary will be necessary, but that aspect also, whether to cross-check that aspect,
Yes,
the
yes.
procedural aspect.
Yes.
I'll see all the things,
Yes.
though Learned Council has contended about 35(3). It is our duty as a court and
Yes.
also for you prosecution to also see the 47, 48 notice also.
Yes, yes,
Since this is the law now.
yes.
So having said that, what I want to ask you is that this Nagaon PS case 559 of 2024,
Yes,
where he got anticipatory bail
yes,
by coordinate bench.
yes.
So in this case, Learned Council has already contended, this is arising out of the same facts. In that case,
But
it should have been amalgamated.
in
This-
my lord case, Lordship, probably it was investigated by CID.
No, my lord,
Maybe,
earlier,
your lordship.
my lord, what is the fact is that, my lord? Several person has filed different.
Yes,
different
yes, they have to be amalgamated.
Yes, that way, maybe that is not amalgamated, that's why, my lord, that is. But the facts remain, my lord. They are running this Kaishap Fukon, my lord, and Anirban Dev. They are the kingpin, my lord, and they have run this business of trading, my lord, illegal trading. And they are, my lord, collecting huge money, my lord, in the tune of 40 crores. And even, my lord, they have collected this money in the, not in the, my lord, accounts of Bullseye. They collected the money through their personal bank account. And I have the proof, my lord. It is, bank statement is there. Even, my lord, they have issued a fake certificate, my lord, to the people, my lord, to collect this money.
Lordship, that is not in the FIR,
No,
that is
legal-
not in the
regarding the
allegation,
legal
your
part, my
lordship,
lord,
even your
is
lordship.
correct. Regarding the legal part, lordship is correct, my lord. Let the CD may come, my lord.
Yes.
They will clear the whole thing, my lord.
Because, your lordship, why I'm saying, your lordship, with due respect, your lordship, the procedural aspect have to be followed, your lordship. Your lordship, I am relying one more judgment of P. Sidambaram, the earlier finance minister, the economical offense, your lordship, the paragraph number 21, I'm relying, your lordship. I'm reading, your lordship.
So can you get CD or CD would be best, if not CD, instructions regarding this, if they can send you scanned copies of that
Lordship,
part
we'll-
tomorrow.
Tomorrow, Lordship,
Can you-
immediately on the.
I know it is not very realistic time
Lordship,
frame.
Immediately on the
because-
reopening, they will produce the case diary. Lordship, because
Reopening,
this is-
of course, it is.
Yeah, Lordship,
we
because
can.
this is not an offense, Lordship, where bail can be immediately granted without going to the case.
That is true.
All
actually.
these
It's
context.
also my duty to check. And
All-
this aspect, Learned Council has fairly submitted that she has contended,
Yes.
but documents will have to be cross-checked.
Yes.
And as I said, we'll not only see 35C,
Yes.
we'll also see 4740.
Yes, and Lordship,
From our side.
Lordship, there are not one or two victims, there are hundreds of victims.
But
And
this
it's-
procedural thing that, you know,
Yes.
that there may be, several victims of an offense, but
Correct, yes.
everyone cannot file an FIR. First information.
Yes.
That is the
Yes.
case.
Yes,
Yes.
All others are 161 statements.
yes.
They'll have
So
to be
Lordship-
treated as one.
Yes,
161. Anyway, this the amalgamation, they don't have to go on registering cases. That will be a mess. That will prejudice him also, as he
but
said.
Lordship,
rightly.
in the other end, Lordship, it comes at a later stage, Lordship, but if there are a number of victims, Lordship, nothing can bar them from filing an FIR, Lordship.
But
It
it's
comes at a later.
no,
stage.
a lay person may not know unless
Yes.
the
Yes,
person takes
exactly,
guidance from a lawyer.
Exactly.
That lay person may feel that
Yes.
I have a grievance, I'll file.
During
But
the
the police authority will have to
Yes.
know.
Because a FIR will be lodged in different police stations, Lordship. So at one
Anyway.
point of time, that can be taken care
There,
of.
wait for a
if-
few days,
Yes,
we'll fix it on Monday.
Lordship, one more thing, your Lordship, one more step. If your Lordship kindly come to 14, your Lordship. Page number, your Lordship,
Page 14.
14, your Lordship. The
Yes.
ground of arrest, your Lordship, if your Lordship kindly.
Grounds
produce.
for seeking
Yes,
police custody.
this is the, in the forwarding report, I am just for the
This
convenience.
is well settled now, that even in very serious matters, when we had to grant bail because of non-compliance. So
Lordship,
there's no dispute about that. This compliance has to be
Lordship.
there.
Lordship,
Whether
Lordship.
compliance has been done in a particular case or not, that is what we have to find out,
Lordship,
right?
one more thing is that Article 20 has also been validated, your Lordship. My humble submission, your Lordship.
That aspect also I'll see.
Lordship, Lordship. Lordship.
As I said, it is our duty from our own
Lordship.
side, we should, in all petitions, like in Anish Kumar, it has been said, whether it is contended or not, it is the duty of the remand magistrate to check it himself or herself,
Lordship,
to whether it's
Lordship.
followed or not.
Lordship, Lordship.
To have that.
So
satisfaction.
kindly hold on for a few days.
Yes.
So you get it on 13th or latest 14th.
Lordship.
13th, your Lordship, kindly.
Nagaon should be possible.
Yes, Lordship, we'll produce it, Lordship.
I'll record them. So,
Let it be on 14th, Lordship, we'll produce it.
your Miss Chetri,
G. Bora, Lordship.
G Board, Learned Council submits that contents that the present petitioner is not named in FIR and that in another case arising out of the same alleged activities, he was granted anticipatory bail by this court in AB number 2413 of 2024 on 8/10/2024. So it is contended that the procedural requirements under section 35 3 BNSS have been violated. Stop. Thereby causing infirmity in the arrest of the petitioner. The learned additional PP submits that the alleged offences are of a serious nature and case diary is essential, but the same has not yet been received first. Learned counsels, his name, you are appearing together?
Yes, yes.
Appearing together, learned counsel, Sinha and assisted by, appears for one of the victims. No, did it, no. Appears for one of the victims and strongly opposes the grant of bail. Full stop. Issue fresh requisition for the case diary. The learned prosecution shall also appraise the court on subsequent dates regarding the procedural compliance. And that is a aspect of fact. We should not be afraid of facts always in life. It is, if it is there, it is there. But the only thing is that now it is not a new judgment.
Yes.
It is there for quite a
Yes,
few months, right? So new judgment, of course, I have some flexibility.
Yes.
Learning window is there.
Yes.
But now, especially in serious cases, it will not be justified on part of IOs to make mistakes
Yes.
of procedure.
Correctly.
Because it's almost going to be 10 months now.
Yes.
Right? List on 13/10 for case there. Okay,
I understand.
you can take it back if you want. You take it.
Your Lordship.
You can take it back and submit it again on the next. Or should I keep it in the file?
Lordship, Lordship.
I can keep it.
Yes, Lordship, Lordship.
It'll be there in the file.
Lordship.
No problem.
16 Lordship, charge sheet has been submitted.
My lord, regular bail application, I am behind the bar 17 days. So investigation is over. At any condition, my lord, I may be allowed to go on bail. All other sections are bailable except section 105. Section 105 is culpable homicide, not amending murder. This is accidental case, my lord. Investigation is over.
For it, a Pramanik, learned counsel for the petitioner and additional PP state. Four 83 bail application. Raju Mandal in connection with Sipazar PS case 114 of 2025. The accused stated to be in pre-trial detention since 31/7/2025.
I'm sorry, Lordship, this is a case of negligent driving, Lordship, as a result of which a
Yes, sir.
woman and a child died. Lordship.
Hmm.
And since charge sheet has been submitted.
Page number
Lordship,
10, my lord.
They may be allowed.
Very
to
unfortunate. These are the allegation in the other, gist of the allegations in the FIR dated 31/7/2025 is that the negligent driving of the, of a dumper, huh?
My lord.
Yes.
Dumper vehicle by the petitioner resulted in death of the woman and her child. The learned additional PP fairly submits that in the meantime, investigation is completed, resulting in a charge sheet. Any details of the charge sheet?
Yes,
Right,
charge sheet
CS number
115/25 dated 24/9/25.
24/9 to
Lordship, my prayer will be, Lordship, let them approach the court below, Lordship.
No, the learned prosecution submits that perhaps the accused petitioner can be directed to approach the learned trial court. However, in view of the completion of investigation and the length of detention, under pre-trial detention, I deem it fit to allow the accused to go on bail at this stage. Accordingly, 30,000 with one security, no, allowed to go, subject to the condition. They shall not, they shall be available for trial, if one commences. Number two, they shall not hamper or tamper with evidence. They shall not intimidate, harass or threaten the informant and informant/family. The bail petition stands allowed and disposed of. Assisted by P. Kolita Likti.
CGM Dorong Mongol.
Concerned learned court, CGM Dorong.
Hello.
This Elista Pereira judgment, after a long time, I read it again just before vacation. That judgment actually is some two more judgments have come. I forgot the name. She had taken out law clerk. So they have actually one or two paragraphs. This thing which we keep debating now, this has been explained. That there is a particular threshold when it crosses negligence.
Yes.
Yes. And becomes, homicide, knowledge homicide.
Knowledge homicide.
Not intention, knowledge. So that thing, many cases have come like that. So we'll need that concept more. The more judgment will come, but that's a leading case.
CD received, Lordship.
May I please, Your Lordship? 483 bail application, the petitioner behind the bar last 34 days. FIR is page 12. And
CD has been received.
Yes.
and my name is not named in the FIR. And nowhere my name is not.
What is the incident?
Incident is,
Let me see. Let us.
is a page 12.
See the appearance.
May I read? 1/28/2025, a complaint has been received from Sri Apurva Kumar Burman of village so and so, that his MB number so and so has transferred by someone in the name of Rafiqul Islam. I am not Rafiqul Islam. I am on behalf of Ashan Ali Sheikh, son of so and so, son of so and so. But the original owner, Sri Apurva Kumar Burman, informed that he had not sold the vehicle to anyone and the vehicle is still in his custody. Next, on examination of official file as well as the database record, it has come to know that the vehicle was transferred on so and so in the name of Rafiqul, son of so and so of Beparipara, so and so in the district of Dhubri, by way of document forgery. Later on, communication with said Rafiqul Islam over telephone number so and so, he confirmed that he had purchased the vehicle from a second-hand showroom situated at Dhubri, and they had made over the transfer of ownership into his name, in the name of Rafiqul Islam. Over telephone and official by letter number so and so, dated so and so, Rafiqul Islam has been asked to appear before the undersigned along with the all documents and with the vehicle and so and so and so and so. But instead of appearing himself, Rafiqul Islam sent to respectively one Tamizur Rahman of Jograpar, Part 4, District Dhubri, and another name is Siddiq Ali of Dhubri, along with the vehicle and documents. The physical verification has done by MBI on, and the chassis number, engine number found mismatch. Among the two representatives, one by name Siddiq has escaped and another Tamizur Islam is still present. Therefore, it has found that the case is forgery and mislead the official and undersigned thereby. This is the FIR, and I am Ashan Ali Sheikh, and my name is not reflected in the FIR. Kindly see the forwarding report, page 12, paragraph number 6, my involvement.
Page 12.
Page 16, sorry, page 16, para number 6, type copy. That the accused person has admitted that he bought the stolen motorcycle from one Azizur Rahman. The accused petitioner purchased the said vehicle from one Azizur Rahman, son of so and so Dhubri, and sold the same to one Siddiq Ali. I purchased the vehicle from the second-hand showroom and sold out to Siddiq Ali. And my involvement, I am not involved in this case at all, and I am behind the bar last 34 days. And
Before I come to the prosecution, just a minute, I will, just let me. This Siddiq, which is whose name, this person has bought the said vehicle from Azizur Rahman and sold the same to Siddiq Ali.
Siddiq Ali.
Okay, investigation has come. Now, this prima facie, it's a serious matter, you know, somebody transferring your vehicle, so selling your vehicle without your knowing, you know. So very serious.
Lordship, I will just try and explain the modus operandi, Lordship. Lordship, the FIR has been lodged by the DTO.
Yes, DTO, because the person, the
Yes.
original owner, he complained to the DTO. He must have complained.
There is a confusion, Lordship. I will just try to clarify,
Okay,
Lordship.
please.
The vehicle that is in question, Lordship,
Uh-huh.
that is, Lordship, it has been mentioned, Lordship,
As-
AS 19G 3149.
Okay.
This is, Lordship, Glamour motorcycle.
Glamour.
This motorcycle belongs to Apurva Kumar Burman, Lordship.
Mhm.
What has happened, Lordship? One other vehicle, Lordship, same Lordship, Glamour motorcycle, Lordship,
Mhm.
another motorcycle, Lordship. That motorcycle was registered, Lordship, and Lordship, it was transferred to another person, Lordship. And Lordship, the name was shown to be of Apurva Kumar Borman.
In that other one.
Yes, in the other one, Lordship. But Lordship, when it was registered, Lordship, for Form 29 and 30 is required while selling the vehicle, Lordship, transfer of ownership. There, Lordship, the photograph is required. There, Lordship, the name is of Apurva Kumar Borman, but the photograph is of another person, Lordship. Thereafter, Lordship, the official of the DTO, Lordship, he is also involved, Lordship. Some other officials are also involved. Thereafter, Lordship, what happens, Lordship, without verifying the chassis number, Lordship, it was done, Lordship. Now, Lordship, this present petitioner, Lordship, he is the mastermind. What he did, Lordship, one, the other vehicle, which was stolen, Lordship, the motorcycle, that belonged to one Tasser Ali. It was stolen from him on 15/1/2020, Lordship. That vehicle,
Tasser
Lordship,
Ali.
yes, that vehicle, what this present petitioner did, Lordship, the registration number of this Apurva Kumar Borman, Lordship, the same registration certificate was issued, forged, Lordship. His fake sale agreement was done, forged. For fake photograph was taken, Lordship, of another person. And that person's photograph was taken from Facebook, Lordship. His statement is also there, Lordship. Even, Lordship, they have gone to the extent, Lordship, the MVI, whose signature appears on the transfer certificate, he was not posted at that place at that time, Lordship. He has also been examined. And now, Lordship, some co-accused are still absconding, Lordship. So at this point of time, Lordship, for the purpose of investigation.
Can I have a
Lordship-
look?
Yes, yes, Lordship.
I am behind the bar last 34 days.
It's okay.
And
just to
and
clear
other accused person is already filed anticipated bail petition before this honorable court, and this honorable court granted interim protection to the
Kindly have
other
a seat.
accused person.
I'll take 10 minutes.
Yes,
Please sit down.
Just to clarify, Lordship, he is the person who sold off this vehicle to the second-hand dealer, Lordship. And he provided the fake RC, Lordship, along with the agreement also, Lordship. He is the one, Lordship.
And in this case, punishment is 7 years,
Mhm.
extend to 7 years, and petitioner is behind the bar last 34 days.
Anyway, so. Application under 483 bail application. Z Ahmed.
That is.
ZH Ahmed, learned additional people. 483 bail application under BNSS 23, under 483 BNSS, seeking bail for accused Ashan Ali SK in connection with Bongaigaon PS case number 203 of 25 under section so and so. The accused petitioner stated to have been arrested in this case on 4/9/25 and forwarded on 5/9/2025. First. The case arose out of an FIR dated 7/8/2025, lodged by the learned DTO Bongaigaon before the police station with the allegation that with regard to transfer of with regard to a complaint received from one Apurva Kumar Burman about someone illegally selling his motorcycle bearing number AS19G3149 without his consent, as he had not sold the same to anyone. It is further alleged that upon examination of the case record, the names of persons like Rafiqul Islam and Siddiq and Tamizur Rahman emerged, and that upon examination of the relevant documents and the vehicle, there was a mismatch was found in the chassis number of the vehicle and that mentioned in the documents. The learned counsel for the petitioner submits that the petitioner is not involved in the offense and he has already spent 35 days in pre-trial detention, and that the offenses are punishable with imprisonment up to 7 years. The case diary has been received. The learned additional PP objecting to the grant of bail submits that the investigation has revealed not only the involvement of the present accused, but also revealed that he is rather one of the mastermind of the alleged activities, which are by way of racket with regard to this allegedly stolen vehicles. It is contended that the documents are manipulated and to sell them to other persons, and the alleged illegal activities involve forgery, impersonation of by photographs, etc. It is contended that some persons of the office of DTO are also believed to be involved, and one of them has been arrested also.
Yes.
And one of them is also a co-accused. Full stop. I have perused the detailed bail objection submitted by the IO. The IO has strongly opposed the bail and has narrated in detail the progress and sequence of investigation so far and some of the findings therein. Full stop. It is submitted by the learned prosecution that there is forgery of signature of one MVI who was not even posted at that location. So the bail objection mentions about forgery of a notary agreement as well. I find force in the contention of the prosecution and the IO that at this stage of investigation, the grant of bail might prejudice the course of investigation. Accordingly, the bail petition stands rejected at this stage. Return back the case. See, after some time, bail petition stands dismissed and disposed. Second appeal,
Yes, my lord. Sir, appeal is preferred against the order passed by the learned court of district judge. My lord, yes, my lord. My lord, this appeal is preferred against the judgment and order dated 25/6/2025 passed by the learned court of district judge South Salmara Mankasar, rejecting the petition filed, appeal title appeal number 1 of 2024 preferred by the petitioner and thereby confirming the judgment and order passed by the learned court of civil judge senior division Mankasar.
That's arising out of execution.
Yes, my lord. Arising out of. The petition was filed under order 21 rule 97, my lord. My lord, what happened, my lord? The present respondent number 1 along with 19 others filed a title suit bearing number 9 of 2012 before the learned court of civil judge senior division Dhubri and obtained a decree for declaration of their right title interest and recovery of possession. My lord. After obtaining the decree, they filed title execution case, which was numbered as title execution number 6 of 2013.
There was no appeal against this
My lord,
trial court decree.
my lord, that was appeal, and there was appeal, and second appeal is there. It is also completed, my lord.
Dismissed.
Yes,
Then execution started.
execution start, my lord. And original application though filed before the learned court of civil judge senior division Dhubri, but due to bifurcation of the judicial district,
Right, that's okay.
it was transferred to South Salmara Mankasar.
Mankasar.
Mankasar Civil Court, my lord. So that case, title execution was numbered before the learned court of civil judge South Salmara Mankasar as 1 of 2021, my lord.
Yeah, that,
1 of 2021.
the new number of the.
Renumbered, yes, my lord.
Yeah.
So after renumbering, the respondent decree holder took step to recover the possession, my lord. When they proceed to take step, I, the present petitioner, who was possessing some 19 lashes of land out of the suit land covered by Act number 72, my lord, approached the learned court of civil judge senior division, the executing court, my lord, by filing a petition under order 2197, my lord, and that petition was rejected. Only ground that, sorry, my lord, my contention was that I am also one of the riot because Zamindari system is there, my lord. Gwalpara tenancy, my lord. So I am
1971 Act will also apply then.
my lord.
1971 Act, temporary.
Yes,
settle- tenancy.
my lord, I am possessing the land as riot, my lord. So I have the right title interest over the land. So I should not be evicted, my lord. That was my contention in the in my petition, my lord.
In the
Under
execution-
order
order
Rule
97,
97.
Rule 97.
Yes, my lord.
So
The
what
learned
happened then?
learned executing court rejected my petition on basis of that my father was Abdul Malik. My father has contested the suit. The respondent appeared, my lord, decree holder respondent appeared and filed that my father contested the suit. But my father was not made party. According to them, my father name was Abdul Malik alias Malik Sheikh, my lord. But if your honor go to the decree, my lord.
They say that your
Yes,
father
ma'am.
contested.
Yes, my lord.
The learned
My
court
lord,
said,
kindly peruse the page number 50, my lord. I have to bring.
the
that
learned
page.
court said that your father contested, but
yes,
you,
ma'am.
you are saying that actually he did not contest.
Yes,
His
ma'am.
name is different.
My
Abdul Malik.
my father is not Abdul Sheikh. Abdul Sheikh. According to them, defendant number 6 or 9, page 50, my lord.
I'll come to this.
I have annexed the copy of the decree, my lord, along with the judgment.
Yes, yes.
Page
Page
59. Malik Sheikh. Malik Sheikh is not my father. They have not made any whisper in the plane.
And
That
son of
Malik Sheikh alias Abdul Malik, my lord.
son of Soreotullah.
Yes, my lord.
Your grandfather's
is
name
not-
is telling,
No, my lord.
your grandfather's
Not.
different.
So Malik Sheikh was not my father. Abdul Malik is my father, my lord. In my petition, in the affidavit, my lord, I have mentioned in my petition. So without making any inquiry as required under section 101, section rule 101 of order 21, my lord, the learned could below without making any inquiry dismiss the petition. So I have filed this, preferred this appeal, my lord, formulating this question, my lord. Substantial question I have page 13, my lord. Three.
Just, the
Three, my
impugn,
lord.
impugn order is at page 64,
Yes, impugn order is, my lord.
page 64,
Yes, my lord.
annexer 6.
Yes, last connection.
Just let me just have a look, at the impugn order once.
I will read it out. One minute, please. 83 page. my lord. Operative part, my lord.
No, I'm just reading it.
Yes,
Don't worry.
87, my lord.
Don't worry, I'm reading it. I'll read the entire one. But you're Malik Sheikh, you said, no?
Yes,
Malik Sheikh. Abdul Malik.
Abdul Malik, my father, but they have a list that Abdul Malik and Malik Sheikh are same person.
Oh, Malik Sheikh.
Yes.
Which you deny.
Yes.
Grandfather's name, what is your grandfather's name?
Yes.
Your grandfather's name. Your
My
father's
lord,
father's name.
I have not read in
Not
capital
mentioned
letter.
because there is confusion because in the list, in the decree which
So-
you showed me,
Yes.
this is mentioned as
They have not mentioned my lord.
mentioned as Malik Sheikh, son of
Her.
Soriutullah Sheikh. Soriutullah Sheikh.
Yes, ma'am.
So Soriutullah Sheikh, I mean,
Yes. ma'am.
person can have same grandfather's name also, but the
Yes.
thing is that
Same.
if grandfather's name will be able to make the distinction.
Yes, ma'am.
So that your grandfather's name you have not mentioned. You
I
don't
have
it.
not mentioned my
You have not mentioned.
mentioned. And they have also not mentioned in their plain
They have
or
also not mentioned.
they have not
Oh.
mentioned that Malik Sheikh alias Abdul Malik. Same case also, RSA was prepared, my lord, before your lordship, between the same party. This registered as RSA number 160 of 2025. It is also admitted on point of number 3, my lord. So that requires the inquiry, my lord, by the learned court below. But that was not done. Whether my father is Abdul Sheikh or Abdul Malik, or whether Abdul Malik and Abdul Sheikh are same person, and whether I am
Oh, according to you, that inquiry was not done.
not done. That is my allegation, my lord. So I have submitted the substantial question on various ground, but 1 and 3. 3 is most important, my lord.
Just a minute.
Page number 13, my lord. Evidence was not recorded, my lord. Though a petition under order 21 rule 97 is required to be considered as a suit, my lord. But that was also not done, my lord. That is why I formulated that I submitted substantial question on that point number 3, my lord.
I see. Now I go back to the, so this is the dispute that the learned court below has also held that your father was represented in the suit as Abdul Malik alias Malik Sheikh.
Not my lord. Malik Sheikh contested the suit.
Malik Sheikh contested.
Yes, my lord.
Malik Sheikh contested.
Because if my father was
No,
named as
huh.
Abdul Malik, sorry,
Yes, no, I am saying that the learned court below said that Malik
Yes.
Sheikh is the same as Abdul Malik.
yes, my lord. But
But according to you, the crux of the matter is that this point, on this point, whether they are one and the same person, sufficient inquiry as required under
Yes, ma'am.
97 was not done.
yes, my lord.
And hence the substantial question.
So that I can, according to the opposite respondent, my lord, Malik Sheikh and Abdul Malik is same person. But that will be considered after evidence, my lord. That was also not done, my lord. That is my main contention, my lord.
So you have formulated four substantial questions.
Out of that, my lord, point number 3 is urgent, my lord. Because in another case between the same person, my lord, RSA number 160 of 2025,
CPC.
your lordship was pleased to formulate that point, my lord, as a substantial question.
Coordinate bench, CPC. First two, other two may not be necessary also. Other two.
Other two,
Main is three.
all this will covered by 3, my lord.
Three.
Yes,
If we cover, no?
yes,
101,
101. Rule. Section order 21. All the question of right title interest required to be considered or determined. That was also not determined, my lord.
The second appeal has to be admitted, I think.
Yes, my lord.
You have a stay order also, stay.
Yes,
stay
my
petition.
lord, because on
Let them appear, yeah.
1310, my lord,
13,
the
you have
date
a-
speaks for report, my lord. In
Till the
the
returnable date. For the time being, till returnable date, and after the
Yes.
appeal, we can also.
Yes,
always
ma'am.
hear. So I will admit this on this question, RSA 168, huh? 168. The instant regular second appeal under section 100 of the Civil Procedure Code 1908, within bracket CPC, is preferred by the 20 appellants herein, agreed by order dated 25/6/2025, passed by the learned district judge, South Salmara, Mankata, whereby the application in title execution case number
whereby the title appeal number 1 of 2024 was dismissing, upholding the judgment and order passed by the learned court. Title case, my lord. Case number 1, 2, my lord.
25/6 passed by the Court of District Judge in TA number 1 of 24, dash whereby the judgment and order dated 29/7/2024, passed by the learned Civil Judge Senior Division, South Salmara Mankasa, in title execution 1 of 21, was dismissed. Full stop. Her PP Das Learned Counsel for the appellants. It is submitted that the plaintiffs had preferred title suit number 9 of 2012, which was decreed on 14/12/2017, and the same attained finality. Full stop. With regard to the same, title execution number 6 of 2018 was initiated before the learned court at Dhubri. Correct me, huh? If
Yes,
I'm
ma'am.
at Dhubri. And subsequently, due to administrative division, the case was transferred to South Salmara, wherein it was re-registered as TS Execution 1 of 2021. Dash again, where the aforesaid impugned orders came to be passed. Good stuff. Sorry, ভুল কথা কৈছো রেসপন্ডেন্টস 20 আছে this petition, this appeal is filed by Ashraful Islam. The appellant Ashraful Islam alias Ashraful Mir. The appellant is only one, Ashraful Islam alias Ashraful Mir. আমার ভুল করে 20 বলি কৈছে না, রেসপন্ডেন্টস 20. Let's do. It is submitted and contended that the present appellant Ashraful Islam alias Ashraful Mia stated to be the son of Abdul Malik and claiming to be in occupation of 19 lesas of land out of the suit land, which was the subject of the decree. And therefore, as a interested third party, he invoked the jurisdiction of the executing court under Order 21, Rule 97/101. Full stop. It is contended that the said petition was, however, dismissed by the learned courts below, vide the impugned orders, and that the aspect of and by holding that one Malik Sheikh, who was impleaded as he was impleaded as OP, he was impleaded as
Defendant number
plaintiff number 9 in the suit. Is the father of the present appellant, and therefore the present appellant does not have sufficient merits to invoke the jurisdiction under Order 21, Rule 97 as a third party seeking adjudication of his own independent rights. Full stop. It is contended that the present the said Malik Sheikh / plaintiff number 9 is not the father of the present appellant Ashraful Islam. Upon perusing the relevant materials available at this stage, the appeal is admitted under Section 100 CPC on the following substantial question of law. We'll frame one only.
Yes, ma'am.
Slightly, I'll modify the language. Whether the learned courts below pass the impugned judgments and orders without following the procedure enumerated under Order 21, Rule 101 CPC, and without sufficiently determining the question, sufficiently determining / adjudicating the question of whether
The appellant has right title interest.
not right title interest, whether this person is the father of this, whether they are one and the same person. I think we can add that, right?
Yes.
And as to whether the father of the present appellant by the name Abdul Malik is the same person as Malik Sheikh, who was plaintiff number 9 in the suit.
One thing, madam.
Yes, correct.
Madam, Another point may be considered,
Yes, we can
whether,
consider another point also.
whether the applicant has separate right of address with the municipality. That point was also raised, madam. Distinct and separate right.
Number two, the following substantial questions of law that I'll do down. no? Number two, whether whether the learned courts below sufficiently determine or they held that he does not have any separate right,
Yes.
right? Because of this reason, that
Because
his
that-
father was contesting.
But my also contention was that I am the riot.
Hmm.
That contention was there in the origin petition. That is why that point is also required.
Whether the learned courts below failed in adjudicating the question as to whether the appellant claiming to be a riot had had separate right, title and interest with regard to the said
19
19 lessons of land
only.
out of the suit land.
Yes.
Also third to any other
Yeah.
substantial
No.
question of law. Third any general, no? Third. Any other substantial question of law that may be required
Yes.
at the time of final hearing. So the appellant shall take steps for issuance of notice upon the respondents, on the 20 respondents.
20 numbers.
20 respondents. Good stuff. List the matter. When should we fix it? After what, about 40 days? Because 1 month will be necessary.
Yes, madam, because Salmara, madam.
After service. List. List in the orders column. Order, it will come in orders
Yes, ma'am.
column, just because it is admitted already. List in the orders column on. Let it be on 1711. 1711. It will be tell you. That's it. This will be similar actually. আমি এতিয়ালৈ যিখিনি লিখিছো সেইটো সেইখিনি আপুনি ইয়াত উঠাই দিব আইএটোত উঠাই দিব then I will edit it. I will edit. Leave it to me. নহ'লে it will be confusing for you. Might be confusing for you. Good stuff. Next. I 3273 of 2025. This in this interlocutory application, the appellant Ashraful May is seeking a stay of the impugned judgment and decree you are seeking stay of the
Yes, madam, impugned order.
impugned order dated
Sorry, madam.
25
Further proceeding of the
Yes,
execution.
yes. No, here you
Yes.
have written 14/12/2017.
Yes. Next jurisdiction.
Execution of the, to stay further proceeding of title execution, say, and so on, so on, for execution of the judgment decree passes.
One of
Seeking stay of further proceedings of title execution case number 1 of 21, it bold করে দিব, 21, 21, dash এটা দিব, seeking execution of the judgment and decree dated 14/12 original decree,
Yes.
14/12/2017, passed by the Court of the Learned, Civil Judge Senior Division. This will be Dhubri. Right?
Originally Thuburi, now execution is made. So further proceeding of title execution, now one of pending before the Learned Court of Civil Judge Senior Division.
Passed by the
South
Court of the
Salmana,
Learned, Civil
Manta
Judge
sir.
Senior Division.
Maybe.
That's all. No? In PS number 9 of 2012.
Yes, madam.
The title, the aforesaid title execution, 121, is pending before the Court of Learned Civil Judge Senior Division, South Salmara,
Mankasa.
stuff. The connected regular second appeal has been admitted today on three specific substantial questions of law. Good stuff. In the given facts and circumstances, the further proceedings in TX 1 of 21 pending before so and so, South Mankasa, shall remain state till the next date of listing. Good stuff. The appellant shall take steps of notice upon the respondents. Next, needless to say that the appellant and the respondents upon their appearance shall be at liberty to seek vacation, modification or alteration of the order of stay as to be list on 17/11/2025 along with RSA. RSA 168/25. Substantial question of laws needs to be formulated properly. It helps. That's why we keep this. Anything else, if it is necessary, we can always. Yes. Time is. Last matter. Instructions.
Yes, my lord, we get some telephonic instruction, my lord, not in a written format. But my lord, he sent an WhatsApp messenger.
So
the
POCSO,
auto-
1510.
Honorable of judgment order, criminal revision petition 262 up to the 25.
Oh, the juvenile matter. Council is here. I don't know. Actually, the confusion is. Revision stands allowed and disposed of. No side effect. Mr. Hawk was there. F. Okay. Finished.